Welcome to Legal Consolidated. My name is Professor Brett Davies, and today we're going to be looking at what happens to your company when you die. Now, a lot of things we're going to go through and study it very carefully, and if you have any questions, start building the relevant document will generally answer the questions. If not, telephone the law firm. So we have a situation where a director dies, and I want to consider the issue of what a director is. A director is a person that operates and looks after your company. It may be your wife, it may be your husband, it may be a friend. In case of BHP, a big public listed company, it's probably people that may not even own shares in the company. But when a director dies, who then controls the company? Because the company is controlled day by day by the director, but it's the shareholder that appoints the director. So the true power of a company is the shareholder. Can the executor sack and appoint new directors to run the company? Well, yes, it's the very nature of the role of a shareholder to be able to hire and fire the directors at will. And if you're the director and you've died, and you are also the shareholder of the company, then the executor of your estate or the beneficiary will merely appoint another director. There's a corporate veil in a company, because it's important to note that you do not own the assets in your company. So when you want to buy that $30,000 necklace for your wife, and you grab the checkbook, the company checkbook, or the company checkbook, it is in effect not your money. The directors do not own the company. The company owns the assets in the company, and the shareholder is the one that owns the shares in the company, not the assets in the company, but the shares in the company. Now, we have an interesting situation where ASIC is the regulator for companies, Australian Securities and Investment Commission, and it's a regulator. It's made a bit of a mistake in the website, so it's a cheap shot to, I'm sure our law firms made mistakes on our websites as well, but it's just a cheap shot to expose some of the information that ASIC provides, and be very wary of regulators. So the Australian Securities Investment Commission regulates companies. They're not your friend. They're regulators. Your friend is your accountant and your financial advisor. So whenever you need help or support, do not speak to ASIC. You speak to your accountant and financial planner and let them speak to ASIC. I currently sit on the legal practice board, and we regulate lawyers. We allow lawyers to practice. Now, we're not friends of the lawyer, we're regulators. Same with ASIC or with the Australian Taxation Office. Your Australian Taxation Office is not your friend. Your accountant and financial advisor are. Do not speak to regulators. Always use a professional advisor. So what's ASIC said here? So on the ASIC's website, they have said that the sole director of a company dies without leaving a will. The complications and distress. The distress can have an even greater impact. What rubbish. When a sole director dies, the company lacks a director, and that is true. But let's say you're following the man of straw, the woman of substance, so all the good assets are in your wife's name, and there's an article you can read on asset protection. The man of straw is a very well-known structure. So, or let's don't speak to my practice manager, I'm using sexist language because it might be the other way around, but let's say that the husband is the person of risk. They own they don't own any shares. They run a business, they're a trustee, they're a director, all those silly things that you do when you have no assets. In which case the wife will have all the good things in her name, the family home, not the car's a depreciating asset. It will have the shares in the company. So in that case, you die as a director. Well, your wife merely appoints a replacement director. It could be your son, your daughter, it could be herself, or whoever it will be, what your wife wants it to be. She's the shareholder. So you don't need to worry about you not having a director at the date of your death. So I think ASIC's quite incorrect there. What I think they should be saying is if you're a sole shareholder, then you need to have the executor quickly appoint a new director. And have a look here. So whether you're a BHP or a public company or trustee of a family trust, what's the trustee of a family trust? So this is where, another training video, a lot of training videos. This is where you have built on Legal Consolidated's website a company, to have one job, and that is to be trustee of a family trust. And that explains how that works. Another purpose of a company might be a bucket company. And this is where, under the family trust, the beneficiary is going to be a company. That's fine. When you die as a director, your wife or whoever the executor will merely appoint a new director. And of course, a special purpose company is where it's a special purpose company can only do one thing, and that be trustee of your self-managed super fund. So, company never dies. A company can live forever. A human being will always die. Very sad. Well, as modern science has it, every human will die. Surely that will hopefully change. Directors do die, and that has to be addressed pretty much straight away after the date of death. Now, another misconception is that, Professor Davies, I have drafted in my will that the replacement director will be someone named in my will. That's not correct. That's not a possible thing to do. The role of director is at the discretion of the shareholder. The shareholder will make the decision who the replacement director is now that you're dead. But Professor Davies, I need to get a grant of probate. I have to prove the will. That could take 3 or 4 months. That's not correct. Well, it does take 2 or 3 months to get a grant of probate. But you don't need generally a grant of probate for a proprietary limited company. Probate's only required under certain circumstances. Where you've got a proprietary limited company, you just go to your company secretary file, log into the ASIC website, get your accountant to do it, financial advisor to do it, and merely as the shareholder have a meeting. So let's say it's the executor, or it could be your spouse. They have a meeting, and within a matter of minutes, the new director is whoever the new director is. So you died an hour ago, we've got ourselves a new director. You're very replaceable. Now, can the executor transfer the private company shares before a grant of probate? So here there's a right and I was going to say a privilege, but it's not a privilege, it's an obligation for the executor to act in the best interest of the beneficiaries. and in the best interest it will be to have a replacement director. So what that executor would do would be to go to your wife. Let's say it's your son is the executor. He will need to speak to the beneficiary, which happens to be your wife in this example, and get her permission, because the executor is a squash cabbage leaf. The executor of your will is subservient. It's a squash cabbage leaf position. Speak to the wife, and she will say, yes, I want, appoint yourself as the director. No, appoint your younger daughter, your younger sister as the as the director. You do not need to get a grant of probate to do that. Now, the other rather extraordinary statement by ASIC on that article, on that screenshot, is that they spruik up the public trustee, or the state trustee for us in Victoria. And it's extraordinary because lawyers, accountants, public trustees charge to do this work. So it's highly likely that the role of executor will be carried out by your beneficiaries. Now, in most cases, the people that are happily married, they'll leave everything to their spouse. So I've left everything to my wife, and when I die, she's my executor, and she'll administer the estate she sees fit. Oh, my wife's pretty dopey, Professor David. It doesn't matter. I reject that comment. Your wife has the skill sets to go to a telephone and ring up a real estate agent to sell property, ring up a lawyer if she can't get the grant of probate herself, but it's quite easy to do on most government websites, to ring up the accountant, do final tax returns, ring up the financial advisor to invest money for tiny tots or whatever needs to be done. So I would not be employing lawyers or public trustee or state trustee to administer my estate. And I firmly believe, I know ASIC's a government regulator and therefore the governments stick together trying to spruik up their own product. It's interesting, I was in my misforgotten youth where I used to take these cases on and try and right the wrongs of the world. I was in a debate with the Queensland Public Trustee and expressing the views I've just expressed, and the Mr. Public Trustee said, but Dr. Davies, by saying that people should not appoint the public trustee, you're just spruiking up your own law firm and other lawyers to do the grant of probate and to administer the estate. Nothing could be further than the truth. I'm a professor in tax law and superannuation. Our law firm does not become involved in administering estates, even though we sell three-generation testamentary trusts with the divorce protection trusts and things. We don't administer the estates ourselves. Your own local accountant will do that. So what happens if a sole director dies? So here in a situation where there was one director of the company, which is common and usual, which we'll come to in a minute, and they've just died. Well, you've got a problem because ASIC wants you to have at least one director. So you have a ship without a rudder. The Australian Taxation Office, ASIC, many other banks will not be happy to deal with your company if it's got no figurehead, if it's got no one at the running the show. So let's have a look at some of the excuse the pun, alternatives. So one idea is to have an alternative director. And this is you often will need to do this if you're a self-managed super fund. If you run a self-managed super fund and you go overseas for more than a couple of years, then alternative director is a good idea. But put that aside, it's never or very rarely a good idea to have an alternative director. Why? Because whether you're an alternative director or a director, you're liable for the assets of the company. And if the company fails, then or you break a regulation, then the alternative director, together with the director, could well lose their individual assets, their family home. So let's say you pick your brother-in-law to be the alternative director. If something happens to that company, he might lose his family home. So from asset protection point of view, it's not good to have more than one director. There's no point doubling up the problem of having a second person. In fact, I'm going to make this comment. There's only two types of people that would take on the onerous and horrible job of being a director. And that's either people with no assets or stupid people. If you have assets and you're a director of a company, not self-managed super funds, but if you're a director of another company, it's high risk. Even if the company just owns shares owns public listed shares, or if it's a trustee of a family trust or unit trust, it's high risk. It's very high risk. So I'd be not, if you like your brother-in-law, I certainly wouldn't be making me suffer that. The other alternative is to put in place a company power of attorney. Now, this is a valid way of dealing with succession planning, because the power of attorney is not duty. It doesn't suffer those same obligations that a director or alternative director suffers, one of utmost good faith and all the rest of it, as far as a directorship's concerned. So it's protected. So if the person holding the legal consolidated power of attorney and there's a problem with the company, they're not liable generally. So it's a much safer position just to appoint company power of attorney. There it is, that company power of attorney. And that explains how a company power of attorney operates. Very useful. We're one of the largest seller of companies in Australia, and most accountants, lawyers and financial advisors building companies on our website will automatically build a shareholders agreement and a company power of attorney as a matter of course, particularly if it's a self-managed super fund. Had an interesting situation recently where the insurance advisor telephoned the law firm and said, Brett, we trying to get some insurance out of the self-managed super fund. There's a corporate trustee, and the super fund, the self-managed super fund, has two directors, as it must do, because mum and dad have to be, as members, must also be the two directors, and only those two directors. But dad's dead. And the insurance company said, we'll only pay out if both mum and dad, as the two directors, sign to release the insurance. The advisor said, but dad's dead. I can't bring him back. He's not Jesus Christ. In this case, if they had a power of attorney, then you would have been able to get around that situation. So very common powers of attorneys. The second way of dealing with and equally important, and both are quite useful, the second way is to put in your will very clearly who is the shareholder or who's going to own your shares at date of death. Now, if you're leaving everything to your wife, it doesn't matter because your wife gets everything. If you're leaving everything to your three children equally after you and your wife are dead, that doesn't matter. But if young Johnny, as your second son, is going to get given this company, then you need to do a specific gift in the will. And there's advice on specific gifts in wills for you. When you come to draft your three-generation testament trust will, it'll take you through that. So another idea is, well, okay, I won't do alternative directors. I'll do a second director, because a company's allowed to have more than one director. Same problem. A director is often going to go down with the sinking ship of a company. So why double up the risk by having a second person take all this responsibility? Now, this is just an example, because it's over and over again the law firm gets contacted to say, I want to control who the directors are upon date of death. You don't do that. You control the shareholders, and the shareholder will call a general meeting within minutes of your death. Well, perhaps not within minutes, but whenever convenient to do so. And here's an example. So this is a specific gift in a will, and here they've appointed all the shares in a company, and they give them to Robert John Smith. You don't need to do that if your husband or spouse is getting everything under the will, and then you're leaving everything equally to your 1, 2, 3 or more children. You won't need to do that, but you will need to put a specific gift in if you're giving the shares in a company to a certain individual, not to all your children. One example of that is a family trust. So it might be that your youngest daughter is running the business in your family trust, and you want to make sure that she gets control of the family trust. So you've amended the appointal clause in the family trust, which is another document, but you also want to make sure the corporate trustee is also under her control in the will. Now, I know that a trustee of a family trust can be replaced by the appointor, but it's a lot clearer to do a specific gift to that younger daughter. The life of a director is horrible. Now, I want you to change your mindset on directorships. From contrary to what your mum and dad told you, they're not positions of authority or prestige. They are really bad things to take on. They've got lots of risks attached to it. After the Tax Acts, the next biggest piece of legislation in Australia is the Corporations Act. And there's lots of good stuff about if a company fails, the directors will go down with the company. So it's not a good thing to do. Australian companies are completely over-regulated. The asset protections are very bad for directors. Please don't do so. As I've said before, there's really some interesting examples of what to do with asset protection. Now, after all this, you still want to control the replacement director. And that's got me wondering who you've been speaking to. Is someone trying to spruik up an expensive, complex, convoluted legal structure in order to achieve what you could do pretty much for free? Now, before you start amending the company constitution and doing all strange deeds and things, which are completely unnecessary, talk to your own accountant, lawyer, and your local lawyer, your financial advisor, and your accountant as to whether it's good value to do that. We've got one client, they amended their company constitution. It cost thousands of dollars in order to appoint the next director. And when they died, the shareholder merely amended the constitution again. They're not double entrenched like the Australian constitution. You can just update the company constitutions. Other times, the company constitution has just been updated because you update the company constitution every so often. Is being a director property? So a block of land a block of flats in Double Bay is property. A mansion in Melbourne is property. A farm in Margaret River is property. Shows as an action like a cheque in your desk is property. But a directorship, being a director, is not an asset. Another thing we often get is that you type into your family trust deed who the directors will be. That doesn't actually work, because the family trust controls the family trust. It doesn't control its corporate trustee. Well, a waste of time. And if someone's charging you money to do that, please talk to your accountant and financial advisor. Shareholder agreements are very good, but they don't replace the director at death. Company power of attorney we've gone through. And succession planning for a self-managed super fund is also do reversionary pensions or binding death benefit nominations. So we now are a full bottle on what happens when you die and you're a director of the company. If you have any other questions, start building the document first. You can telephone the law firm, but make sure any of our documents, start building the documents first, because it answers most questions enjoy the free resources of this law firm.